Prashanti. Now,
Hello.
this upcoming question is definitely, when someone goes through this issue, they should definitely seek services or help from an attorney like Prashanti Reddy. She can be reached at 212-354-1010. Now, this question here is, what happens to PERM and H1 if the company is acquired and employees move to the new acquiring employer? The case here is company A plans to sell off a part of the business to company B. Maybe they're selling assets. Who plans to spin it as a separate entity, company C. So there's a company A, and the company C is probably company B. So what happens in this situation? This is a very typical and critical, and which is a standard process that happens. Acquisitions, asset purchase, or successor in interest. So can you explain a little bit and how you can help in these type of situations?
So in a successor, so this it depends really, but in this particular case, they're only selling off part of the business. So a successor in interest case happens when there's a merger or acquisition, and when the interests and the liabilities are both sold. So not only are they selling off, or the new company has to be responsible for both, um, not just the profits but also the liabilities. So if the liabilities are also moved, then it could be a successful successor in interest situation, and it's possible that the green card um, can then be transferred. But also you have to remember that AC-21 allows transfer of green card anyway. If the I-140 is approved, if it's 6 months since the 485 has been filed, you can just do an AC-21 situation, AC-21 filing in this situation. You don't have to worry about successor in interest. But if I-140 is not yet approved, then yes, successor in interest has to be proved, and this is possible if you're able to show that, as I said, liabilities as well as the interests have been taken over, and a merger has taken place, even if it's only part of the company.
So if such situation occurs where they're only picking the assets, and for example, it's very in staffing industry,
Yeah.
they go to another staffing company, purchase 50 employees and the client contracts. Now I have two questions here. One, an H1B refiling or amendment, is that required? Number one. Number two, if that is not required, what is the process to notify the immigration about this change? Because at some point they have to go for a visa stamping, and there's a lot of nuances attached to this.
So for the H1B, if the interests and liabilities, if everything has been transferred, assets and liabilities have been transferred, then it's a smooth process. You don't have to file anything. You just have to um, submit that documentation at the time of whenever required. Like if you're filing an extension, that at that time you submit the M&A agreement showing assets and liabilities have been taken over, and you submit the original H1B approval, and you file for an extension. So you don't have to do anything really. But if, as you said, in this situation, assets and liabilities, only assets have been taken over, not the liabilities, then you have to file a H1B transfer for all the employees that have been moved from company A to company B.
So it's an H1B transfer. This is not an amendment. Simply they pay $460 fee. They
No,
have to
it's a
pay, the new
transfer.
employer has to pay the full fee.
Correct.
If they have over 50 employees, now we're talking about a whopping $6,500 plus if
Correct.
they send.
Yes. Right. Correct. Yes. That's why it might be a good idea to take over liabilities and assets.
No one wants to take over liabilities, right? They only want assets.
Liabilities, right?
All right. Thank you, Prashanti, for answering the question.
You're welcome.